Hi everyone, this is Mallory Flowers on behalf of Jennifer Schaus and Associates. We are coming to you live from Washington, D.C., and welcome to our Webinar Wednesday series. All of our webinars are held every Wednesday in 2018 at 12 p.m. or 12:30 Eastern Time, and our speakers range from accountants to attorneys and other industry professionals. The full schedule of the rest of the year is on our website underneath the webinar tab. In the interest of time, we do not take questions. Our speaker's info is posted on the last slide, so if you have any questions, please contact the speaker directly. The recordings are on our website underneath the Archived Webinar tab, as well as on our YouTube channel. And this is just a quick blurb about us. Jennifer Schaus and Associates is based in downtown Washington, D.C., and we help both product and service companies with federal contracting. Our clients are domestic and foreign defense contractors and civilians. Our services range from market analysis reports to contract vehicles, including the GSA schedule. We can also help you with proposal writing and post-award contract administration. More information about our services and upcoming events can be found on our website. So we're going to go ahead and dig into today's presentation, and our presenter is Andrew Mirsky. And you can find more information about Andrew and his business on these two slides. And we're going to go ahead and dig in. Today's presentation is opt-in consent rules under new data privacy laws. And like I said, Andrew Mirsky is our speaker today, and I'm going to go ahead and hand it over to you.
Thank you, Mallory. Can you hear me all right?
Yes.
Okay, all right. Just shout out if I'm not coming through. Good afternoon, everybody. My name is Andy Mirsky. I am an attorney in Washington, D.C. I also have an office in New York City. And I do work with technology companies, small to mid-sized technology companies, including government contractors, including a lot this year with privacy law, and specifically the new general data privacy regulation in Europe and its application to my clients in both primarily in the US with a few clients in Europe. That includes government contractors, or I will describe how it may include government contractors, and specifically for purposes of today's presentation, the new consent rules requiring consent under the GDPR and a series of related laws, in particular the e-privacy directive. And what got me interested in this topic was the thing which the question I'm getting from a lot of clients is, why are you seeing all of those cookie consent banners, which you see on the bottoms of a lot of websites. You're probably seeing them themselves. Some of you probably have them on your website. And more broadly, next slide, please, Mallory. More broadly, why the seemingly sudden emphasis on consent, and why are you getting so many demands and requests and so forth for consent? Next slide, please. I just included here in this slide an example of one that I had seen from, this is actually a music sharing site. A pretty good, pretty friendly request kind of thing. Some of you may have seen. Some of you seen hundreds of these. Just a note to let you know, we've updated our privacy policy to clarify how we use your information. Then you'll see below. You currently allow us to send you occasional non-essential email updates. You can opt out. And today we are going to talk in the next 10 or 15 minutes about these, why you're getting these kinds of requests. Next slide, please. The GDPR, which I'm sorry if I referenced the shorthand, is the shorthand for the EU's General Data Protection Regulation, which and this is actually from the official government site in the European Union, replaces the 1995 Data Protection Directive, which had been the operable law until May of this year, and was designed to harmonize data privacy laws across Europe to protect and empower all EU citizens' data privacy and to reshape the way organizations across the region approach data privacy. If you could turn to the next slide, please, Mallory. To answer your obvious question of why is this person speaking to me today about a European law? Here's why. GDPR applies to any organization, that could be anywhere, that processes or stores personal data of EU citizens or monitors behavior of EU citizens. This is one of the very big changes of this law as compared to the previous law. You don't have to be physically operating in the EU to be covered. If you are operating in the EU, you're definitely covered. But for purposes of my typically American audience, you're probably more interested in whether you are operating outside the EU and whether you can be covered. And the answer is you can be. If you tick one of those criteria about processing or storing personal data of EU citizens or monitoring the behavior of EU citizens. Processing or storing what? Exactly, personal data. Next slide, Mallory. Okay, great. I said personal data. This too is an expansion of previous law. So it encompasses much more than simply what had been referred to as personally identifiable information. Things like names, email addresses, social security numbers. Those are obvious personal data. But the newer law, the GDPR law, includes IP addresses, application user IDs, GPS data, biometric data, cookies are now covered under the GDPR as personal data, as well as everything that you would have traditionally thought was personal data. Next slide, please. So, okay, if the GDPR applies to you, so what? I'll just mention this briefly. This is another big thing, and this is why people are, this spring this certainly caught people's attention. Even for minor breaches of the law, you can be tagged for up to 2% of your global annual revenues. That's our 10 million euros. For serious violations, it can be up to 4%. That's 20 million. And just to get, you may have seen in the news just yesterday, this wasn't under GDPR, but it was by the same European regulators. I think it was Google was tagged with a 4 billion, that's billion with a B, $4 billion penalty for antitrust violations. I think it was Google. I may be blanking. Which is the largest fine of that category ever, to my knowledge. And it was many commentators thought it was the EU's way to send the signal that they are serious about data privacy, data protection, and serious about taking their obligations to regulate technology companies seriously. Okay, next slide, please. So that's the 10,000-foot picture, closing down on when the issue of consent comes up and why you need consent. There is a requirement in Article 6 of GDPR that any processing that you do of personal data of EU citizens must be done under a lawful basis. It must be it's called the lawfulness of processing. And there are about 6 or 7 categories of things that qualify as a lawful basis. Consent is one of those bases, but there are others. I'll mention briefly 2 or 3 others: the legitimate interest criteria, or the performance of contractual obligations with an individual. But for purposes of today, consent will satisfy the requirements generally of establishing a lawful basis, which you must establish in order to process personal data. So, just taking a plain English step back, if you process personal data of EU citizens and you obtain consent to that processing, you are generally going to be well on your way to compliance with the new law. The next slide, please. But just to be clear, if the data that you collect is not personal data, so it doesn't apply to any data collection processes, it doesn't apply to general operating a website. If you're not collecting personal data, by the definition, the broad definition that I gave you, the consent rules do not apply. And I have some examples here that are tricky, but they illustrate the point. Most websites use some sort of tracking software or tracking pixels like Google Analytics. So the question, do you have to obtain an individual's GDPR sufficient consent in order to track their website visits? So in other words, if you use Google Analytics, you are sending data. There's a Google tracking pixel on your website, and data is being sent to Google to analyze it. Do you need your user's consent to do that? There's a typo here. The first answer should actually be no. If the data you track about customers is not personal data, it does not identify an individual or an individual identifiable, then the consent rules do not apply. So, for example, if all you're tracking is type of action, not demographic information, for example, that would be no. The next category, however, is yes. If you do use analytics data or tracking pixels to track demographics and other personal data, you do need consent from your users or one of those other lawful bases to process the data. But you really want to be careful about this. Google Analytics is the 800-pound gorilla, obviously, but they're not the only tracking pixel out there that people are using, and you're almost certainly using other plugins, video embeds, social media share buttons, and the like. All those are tracking, and they are sharing personal data. So that is where the issue of consent again comes up. Okay, next slide. So if the data you collect is personal data, but does not relate to EU citizens, then the GDPR consent rules do not apply. Is that true? Well, it's generally true, but there are exceptions. The EU laws, the GDPR and the e-privacy directive, which I'll talk about in a few minutes, they would not apply. But there may be other laws. So, for example, U.S. laws, if you are processing data of U.S. citizens. As many of you may know, California just a week or two ago passed the California Consumer Privacy Act of 2018, which some people are calling, somewhat inaccurately, some people are calling it a mini GDPR. But it is a much more aggressive law than is common in the United States. And there are other laws. Massachusetts has had laws, and many other states have had laws of fairly aggressive state privacy laws on the books for a while. So just because you do not collect data about EU citizens does not mean you do not have consent requirements in place, but generally it does mean you're not subject to the laws that we're talking about today, the GDPR and e-privacy directive. Okay, next slide, please. So you might ask the obvious question, if those EU laws don't apply to US sites, why are you still getting so many consent requests? Why are you getting the cookie consent banners? One practical problem is geofencing, which is basically the concept of being able to segregate website traffic by geography. If you're getting traffic from the EU, you can segment it and therefore serve them the consent forms. And if they're not from the EU, you would not have to do that. It's not very quote here from a blogger, Jeff Sauer, who has Sawyer. I'm sorry. He points out he has 74% of his visitors that are not in the GDPR area, and he doesn't want to have to hit them up with cookie consent banners every time they land on a site. That's true, but he also points out it's not always easy to find a solution to make that segmentation or segregation. Other reasons you're still seeing it anyway, including geofencing, is industry best practices, the herd mentality because everyone else is doing it. People in the United States worried about the states, California, and also there are not just California state laws like California's, but also the FTC at the federal level and the mini FTCs or the baby FTCs, which are the state attorney generals at each of the states. A even better reason, and in my view, the best reason of all that people are doing it, even if they're not subject to the European laws, is escalated expectations by your customers. The GDPR plus related privacy laws like the e-privacy directive, plus things in the news like Facebook, Cambridge Analytica, have gotten customers raised expectations immensely on what is expected in terms of what you see on websites and uses of data, even if technically speaking you're not subject to those laws in the United States. Okay, please go on, Mallory. Thank you. So this is a very detailed slide on how to obtain the consent. I won't go into too many specifics here. This is intended to be a summary. GDPR Articles 4 and 7, which you can look at, and I'll have some examples right after this slide. This is the big change with GDPR with consent was from the previous law, the 1995 law, was an explicit requirement of affirmative, prominent, specific, unambiguous consent, not implied consent through, you continue to use my website, therefore you consent. It's very clearly must be affirmative. There's an example below. Click wrap agreements or long-term terms of use where consent is buried in legalese, is no longer frowned upon. I have a quote from GDP Recital 32. Ticking a box is a very approved way. Anything that indicates any statement or conduct which clearly indicates the subject, the data subject, the individual's acceptance of the proposed processing of his or her personal data. You also have to provide, I'll just mention this once in passing here, notice of a right to withdraw consent. You'll see when we get to the next slide, the example I have does not actually have that, but privacy policies must provide, or somewhere on easily accessible, notification that that the individual, when giving consent, has the right to withdraw that consent. Okay, if you can go to the next slide, Mallory. Here's an example from, this is actually a UK grocery department store, Walmart type shop, with a pretty good actually example of proactive GDPR compliant agreement to terms and conditions and contact. Now, under the terms and conditions, you'll see we want you to know exactly how our service works and why we need your registration details. This is for people registering on the site. Please state that you have read and agreed to these terms before you continue. You must accept the terms and conditions. And you actually have to move the button to the left and turn it green in order to register for the site and use it all. If you go back, can you go back one slide, Mallory? Yeah, you see this actually checks a couple of these boxes. If you look on the right side of the bottom, unbundling. So if you have consent to multiple uses, as you saw in that example, they have to be separated or at least distinguishable. So you're not just lumping everything, you're blanket consent. Clearly distinguishable from the other matters in an intelligible and an easily accessible form. Okay, go back to that next slide. Yeah, great. And so you see also below, when I mentioned unbundling, there's a separate consent button below for marketing, contact permission, sending money off coupons, exclusive offers, etc. You don't necessarily have to have it spelled out in this level of detail, but this is a very good example. Again, this links out to the terms and conditions, and is a very good example of an affirmative, unambiguous consent. Okay, next slide, please. I mentioned generally, and in the top, it's in the title, cookie banners, which are actually, can you go one more slide, Mallory? Yeah, this is an example from a development company in offshore in India, actually, called InfoBeans. If you look on the lower left, that's what's called the cookie banner or the cookie dialog box. This website stores cookies on your computer to provide the best possible functionality. You guys have probably seen about 900 of these. It says what we use this information for. To find out more, click here for our privacy policy. Okay, thanks. that's a cookie but banner. Okay, you can go back one, Mallory. Thanks. So why are you seeing all these cookie consent banners? This is slightly complicated. There, I did mention the e-privacy directive, which is a law from I think either the very early 2000s, updated in 2009, and about to be updated again in connection with the GDPR. It has not formally been adopted yet. So the e-privacy directive is still active law. It requires consent for all non-essential cookies. So if they're essential for use of the website or the service, consent is not required. But the big thing with GDPR, the consent for purposes of the e-privacy directive is now defined by reference to the GDPR, which, as we just talked about, must be freely given, specific, informed, unambiguous evidence of clear affirmative action. So what you used to see was, well, our view was you use our website, therefore you have, by doing that, we implicitly accepted our terms and conditions and our privacy policy, including our cookie policy, which was embedded deep inside our privacy policy. What you are now seeing is that by virtue of the application of GDPR's new consent, affirmative consent, or at least unambiguous consent definition, you are now seeing a race, and you saw this going back 6 months ago with the rollout of GDPR. Websites, at least if unless you have visited the site before and accepted the cookies, so you have the cookies in your cache, you are now seeing the cookie notice. It is unclear if implied consents are still valid. So if you go to that next example, next, yeah, one back. I'm sorry. Yeah, this example is probably similar to many you'll see. You don't actually have to click on the OK thanks button to use this particular site. Some of them require that you do, some of them simply notify you and keep it out there in your face until you, for any pages you go on. It's unclear if that alone is acceptable. The general practice today, as you've probably seen, is that as long as this is front and center and it's in your face, it will satisfy the requirements for both GDPR and the e-privacy directive, which, by the way, is often referred to as the cookie law. For those of you who may have seen that term. I will also mention that there is some ambiguity about whether even this requirement, if you accept cookies through consent, whether you can then be deemed to have accepted the things that cookies do, including consenting, collecting personal data like demographic information, for example. There's some uncertainty in the law about this and whether you need additional further consent. That's something that's hopefully going to be cleared up on this new e-privacy regulation, which is an update of the cookie law, which has been proposed but not yet implemented. Okay, one more slide. Just to wrap up, these are a few takeaways. I just want to mention a couple things. Consent is not always a true opt-in. So we talked about this notion of opt-in. GDPR's big thing was making opt-in, largely doing away with the concept of implicit opt-in, and therefore, giving an opt-out regime. GDPR's general framework is affirmative, unambiguous, explicit consent. There is a category, you've probably seen these in the example I had at the very beginning of this presentation. They were giving you the option to opt out from them marketing their emails to you. You'll see that, and that's sometimes called the soft opt-in. You'll see that in situations for data that is effectively that website publishers and are viewing as grandfathered in because you can argue or you can prove or demonstrate that you obtained consent in some way or through transactions or something like that prior to the GDPR effectiveness. And that's why you're seeing people take that approach of the kind of soft opt-in and not requesting new opt-in. You've probably seen that. You'll see more of that. Number two, in order to process personal data of EU citizens, I did mention that a lawful basis is required. We talked about consent today. Consent is one lawful basis, but as I said, it is not the only lawful basis. And as I mentioned in the example of the pixels, so the tracking pixels, it's important to consider all of the personal data you collect, all of the uses, and all of the third parties with whom you share. Because if you're sharing, there may be very obscure, kind of remote ways you're collecting data. You do generally need some sort of consent or other lawful basis to do that with personal data of EU. To the bottom, this is I just intro to the topic. I encourage you to speak with your legal counsel about specific actions you take. I think that is all. Next slide, Mallory. Oh, great. Keep calm and prepare for the GDPR. Fabulous. One more. Oh, that is all. Thank you very much. If you do have questions, my contact information is there on the last slide. Back to you, Mallory.
Thank you. That was a lot of great information, Andrew. Thanks for sharing your time with us today, and thank you for everybody who joined us. If you have any questions, like Andrew said, please contact him directly with the contact information you see on your screen. Next week, we are covering compliantly involving non-U.S. persons in your federal government contracting business. And this concludes our webinar. Thank you, everybody.